Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer Podcast. I'm your co-host, Thomas Vick, and I'm joined by my co-host, Seth Wilson. Seth, how are you today?
Thomas, we're doing great. It's a kind of a snowy morning up here in Hamilton County, Indiana. So how is the weather down in Greenwood?
We got probably about an inch and a half of snow this morning, so had to shovel the driveway, but it wasn't too bad. The roads outside the neighborhood were just fine, so not too bad. How much shoveling did you have to do this morning?
Yeah, it's the same. I think we probably had two and a half, maybe three. So it was just enough to get the shovel out versus using my leaf blower as a snow blower. So, I kind of like blowing the snow. It's kind of fun, but got the shovels out this morning, got everything cleared off so we could get in here. But yeah, thankfully, we're so fortunate that around here the road crews keep everything clean and safe for us to get to and from where we're going. So appreciated that. Had a couple school delays this morning for the kids, which was probably wise, just giving them a little bit more time to let the roads dry up a little bit, get that traffic through. So
Yeah.
so it's been a good morning, but I was excited to see the Friday roll around and get a chance to chat with you about things. And hey, I noticed a couple of updates that you'd made to your website this week. So I thought maybe you could tell us a little bit about those changes.
Yeah, some exciting changes to the website. The first big change is that I've added a welcome video to the website. So when people go to vicklaw.org, they'll see a video of me kind of explaining what you can find on the website. And we talk about, you got information about estate administration, estate planning, Medicaid planning, all that kind of stuff is on the website. So I kind of just introduce the visitors to the website to those options. And of course, we also have a new PDF that we've generated, and I think a lot of people on Facebook might be able to see that more readily. But it has information about estate planning and definitions of terms that people may not be familiar with, like what is a trust, what makes up a trust, and what's a trustee, and what's a will, and what's a living will, what's the difference between the two. Those kinds of topics are included in this PDF, and I think that's going to be really exciting. I think it's going to be a helpful tool for clients or prospective clients to review in getting ready for a consultation with me.
I agree. And you were kind enough to share a copy of that document with me, and just so easy to read and navigate. And what I really liked about it was if there was additional information available about a particular topic, I could click on that link and go right to a more in-depth explanation on your website. So really, it just such a great way of, excuse me, making that information available and accessible from educating the clients so that when they do end up needing to talk with the attorney, they have enough resource to feel like they've been comfortable with what's going on. And thought that was kind of a nice hand in hand fit with what went out on the blog digest today in terms of what are kind of just the basics that you should know about in terms of your estate planning. I think that's one of the big questions that we answer quite frequently. And so it's always helpful to kind of go through what are some of the most essential things that should be in place as you approach this topic of end of life planning.
Yeah, so the blog topic that went out today in the digest was 7 essential end of life documents. And the first one that is mentioned in the article is a last will and testament. And last will and testament is really important because you may not want your estate, your assets, to go to individuals that Indiana has sort of selected for you. We call that intestate or intestacy. And if you die without a will, you die intestate, and Indiana provides, the scheme by which your assets will be distributed. And that, usually it's, spouses involved with that and children, but you may not have children or you may not be married. And so you have a different kind of plan that you might need to have. So different wishes than what Indiana has laid out for you. And so that's one reason why a will is important.
Yeah, I agree. And I think one thing that is confusing is kind of the intersection between the last will and then the next item on the list, which is a living will. And I think probably better defined as an advanced directive. And so you see those terms kind of used interchangeably in terms of the advanced directive and the living will, but there's a lot of confusion with my last will. And so really that's those are two separate important documents. That advanced directive or living will is literally that advanced directive that I am telling my designated individuals, this is what I want to have happen to me in the event that I have sort of that last of life situation. You know, I've got an incurable disease. The doctor has made the determination that the effort to sustain life is probably not going to work. And what do I want to have happen in that instance? And it's not required that you have one signed. You can leave that up to your medical folks. But I do hear that term used a lot to reference my last will. And so I always ask the clients, okay, what is the intent of what you're trying to accomplish, to make sure that we understand that, because those are two confusing terms.
Yes. Yeah, they are confusing. And I definitely agree. Advanced directives and living wills are important. And, in Indiana, a living will can be included in an advanced directive. And so they can be, one and the same thing. The next one is a power of attorney. And we really are thinking about a general durable power of attorney for financial decisions when we say a power of attorney. And that's important because you want to select who can represent you, who will represent you if you're not able to make financial decisions for yourself anymore. Would you rather select somebody that you love and trust, or you may trust a court, but you probably don't love them, and so a court would have to make decisions for you through a guardianship if you don't have a power of attorney potentially, and that's really important, and we consider it an essential document in your estate planning.
Yeah, and I think what's one of the ways I kind of think about this is that power of attorney in this context is kind of that during life incapacity, or even for convenience sake, where you need someone to step into your shoes and manage your affairs from a financial perspective. And there are different types of powers of attorney that folks might be familiar with if they've handled a real estate closing as a married couple and they've given a limited power of attorney to one of the spouses to sign on behalf of the other one. But your general power of attorney, if it's effective at that time, can serve that same function based on the powers granted in the document itself. And so very, very important. And Thomas, you mentioned, again, something that we highlight all the time is making sure that you've designated someone to step into those shoes if and when that becomes necessary, because you never know if and when that incapacitating event may occur. And you don't want to be in a position where you have to petition the court to establish a guardianship to allow you to act, when you could have done that through hopefully a much simpler process through the power of attorney.
Yeah, and that topic has been on my mind recently for a few different reasons, but one of the most heartbreaking tasks that I do from time to time is petitioning for guardianship when the wife is the petitioner and the husband is the one that is incapacitated, or vice versa. When a spouse can no longer make decisions for their their incapacitated spouse, it's really a heartbreaking situation, and it almost seems like, should the court really be involved? But that's the way our legal system is. We have to petition for guardianship to get court authority for the wife or the husband to make decisions for the spouse, and so that's why we always emphasize in this podcast and in our meetings with clients, you need to get a power of attorney in place.
Yeah, and if your documents are a little bit older, and this kind of relates to the next topic of the healthcare power of attorney and the intersection of the healthcare designation or the healthcare power of attorney used to be in Indiana, at least, kind of could put everything together in one document. And now there's actually a statutory requirement that those documents be separate and independent of each other. The old ones typically will still work and if they were executed at a time prior to the change in the law, but you don't want to be in a situation where you need to find out whether you're right or not, and have it not work for you, because that's a challenge. So the healthcare power of attorney, maybe talk us through a little bit of what the difference is there.
Yeah, so a few years ago in Indiana, you could have a healthcare power of attorney built into the general durable power of attorney, and you could just have one document. But now they've kind of gotten rid of the healthcare power of attorney provisions in the Indiana code, and now we are relegated to an advance directive or an appointment of a healthcare representative. And so, in updating documents, it might be a wise idea to just get those separate if you have them all built into one document. And so, yeah, that's an important thing to keep in mind when you're looking at reviewing your estate plan. And while we're talking about healthcare documents, I think it's important to get a HIPAA authorization as well. Mm-hmm. Because a HIPAA authorization can be a shorter document than the Healthcare Advance Directive, and the HIPAA authorization will allow individuals to be able to talk to their loved ones, doctors or nurses or what have you, and that can be a convenient way of being able to accomplish that.
Yeah, and one thing we consider for clients in the right circumstances, adding additional family members or loved ones to the HIPAA release, even if they're not a decision maker, because there are some circumstances where it's helpful for those family members, even if they don't have the requirement of making a advanced directive type decision or making the decision of, hey, do we go to surgery or not, or something like that, but they need to provide input to the decision maker. And so having access to that information can be helpful in the right circumstance. So sometimes you might consider adding additional folks to the HIPAA release to take care of that eventuality ahead of time.
Yeah, that's a good idea. And then there are some other items in the blog post about organ designations. That really is kind of what you do at the Indiana BMV. You do that through your driver's license here in Indiana. But one of the other documents I wanted to talk about was a living trust for asset management purposes. It's a really advantageous way of doing an individual's estate planning, because you're sort of starting that probate process ahead of time. You're getting all your assets as much as you can and under the umbrella of your trust. And then regardless of what happens to you health-wise, whether you have a long-term care event or an incapacitation of some kind, or upon your death, your trustee, your successor trustee, will be able to come back into your shoes and manage the assets in the trust and be able to accomplish your wishes. For instance, maybe you're a parent with small children, and your kids are going to be depending on you to support them during their minority time frame. And if you become incapacitated, your successor trustee can come in, not only provide the benefits of the trust to you and support you, but also you can build into that assets can be used for the care of your kids and supporting your dependents. So I think that's a really good way of doing estate planning.
Yeah, and it's life management. I mean, really is kind of what's happening. And I really like the trust from the stewardship model, and the idea that we really aren't owners of the material possessions that we have. We're stewards of them. And so putting those assets into a trust changes your relationship to that, both legally and practically. And so it helps you see things just a little bit different as well. And so you're now managing and stewarding these funds for the benefit of not only yourself, but also your beneficiaries. And so it kind of brings some structure to that, if you will, because there's some things that you need to comply with. And there's a lot of the benefits that you just talked about that is part of that as well. So that's kind of the practical side of the trust and the financial management piece. Is it really gives you a great tool set to navigate most of the eventual potential problems that you may face in life in terms of capacity issues and eventually even a probate scenario where you don't have to involve the court in the distribution of your estate if those assets are under the trust appropriately. I do get this question quite a bit, Thomas, and I don't always have a great answer for it because as an attorney, you never want to feel like a sales guy and saying, "Hey, I'm trying to put you in this vehicle over here," when what you really need is a minivan or something. So, when is a good asset base sufficient to consider a trust versus a will?
I think it makes sense even when you're young adults with children. I think it makes sense at that point in time to go ahead and get a trust, because, as young families are getting started, maybe they're getting their first house and maybe they have some life insurance that they've gotten, and, what's going to receive that life insurance whenever the parents have an unfortunate, untimely death. It could be the trust, and that would be the best possible place for it to go. If it's not, if you just name the child as the beneficiary, then you're going to have a loved one having to go to court to get guardianship of these children to handle their money, where you can make it a private affair, and your loved ones who will be taking care of your children will just be able to have essentially immediate access to those funds without having to go and get court involvement.
Yeah, and I think that's a common sort of misperception, if you will, about a trust is, well, I need sufficient assets to do that. Well, really, the assets that you have are worthy of a trust, if that makes sense. And you should consider that as part of your overall financial plan. And a lot of my counsel on this, if you will, is really it's a comfort level for you as a client. So if you feel like the trust is too complicated and I'm not going to use it and understand it, don't get a trust, because you can create additional confusion down the road versus something that you say, no, I get this and this makes sense to me and I'm comfortable with that. Again, the whole point of the plan is that you have peace of mind and you're really not thinking about the plan all the time. You're really focused on living your life and generating the assets to transition at some point.
Yeah.
And so that's kind of the rule of thumb that I have. But when folks are really trying to understand what are the pros and the cons and the benefits and detriments to a trust-based plan, there's just a lot of good benefits. And I think those, in my practice, I've seen the benefits continue to grow on the pro side of the ledger, so to speak, versus the con side.
Yeah. And we're certainly not old attorneys. We've been doing this for some time now. I'm getting close to 10 years here this year, which is kind of crazy. And you're a few years ahead of me. But even in our career as attorneys, we've started to see how a trust can benefit individuals, whether it's putting a house into a Medicaid asset protection trust, and now there are some health difficulties, but you're close enough where your a house is going to be protected in the Medicaid asset protection trust for nursing home costs and that kind of thing, or special needs trust planning that has been built into a revocable trust is now being used. Things like that are really cool to me, to see how a trust can really benefit families.
Yeah. And just the seamless nature of it is so nice, because there's maybe a document or two to sign in terms of transitioning to a successor trustee, but that gets filed with the trust. You don't have to put that in front of the court. You don't have to wait for timing. You don't have to really even wait over a weekend for the court staff to get to it, set a hearing, and do all the things that need to be done. And so for the most part, it's a very beneficial thing as well. in the right circumstance. And so that's, as we say all the time, right? As attorneys, it's always very fact dependent and situation dependent. And your situation may not fit it for one of the 100 exceptions that may exist or something, right? So it's always good to reach out to an attorney, but hopefully the information that we're providing gives you some context and some other things to consider as you're thinking about, what are these essential end of life documents that I need to have in place.
Right. Good stuff. Well, Seth, I appreciate it as always. Always enjoy the conversations we have about estate planning and kind of going back and forth with ideas that we have. How can people get in touch with you?
Well, I appreciate it, Thomas. I was chatting with a friend the other day, and it was kind of funny. I got talking about what I do, and I realized they weren't really all that interested. And I was super excited about all the options in estate planning world. And I think they really had a much smaller question than what I was trying to answer. And I said, "Oh, sorry, I'm overwhelming you with stuff." So we love this stuff. We love serving our clients in this way. And hopefully, the information here is helpful. And if we can be a resource for you, we're here in Hamilton County, right in downtown Noblesville. And that's our web address, noblesvilleattorney.com. How about you, Thomas?
viclaw.org is the best place to reach me. I'm located in Greenwood, Indiana, and on viclaw.org you can book a call, like I previously mentioned, and talk to me by phone or by Zoom. It's a great way to get in touch with our office. Well, I think that's about it for today, Seth. Appreciate it, and we'll see you next time.
See you, Thomas.